Good, good. Everybody, we're going to get started. We're going to have people dribbling in I keep getting emails. Folks have court, they're stuck, they're coming over, but we're just going to get moving in short introductions. Welcome to our seminar on representing people at bail hearings. And it's really great that the National Association of Criminal Defense Lawyers is helping put this on. They're working with us, not only for this seminar, but to create a manual. Janie and I are putting that together, and she's going to talk to you today a little bit about the law. But it's a work in progress, what we're doing. So what you hear today, some of it you can take to the bank, some of it is in flux. But I wanted to just briefly introduce our guests, and they're going to introduce themselves in more depth. But we have Bonnie Hoffman, who's the Defense and Training and Reform Director at NACDL. She just started recently. I've known Bonnie for years because she and I were on the NACDL board together. She was previously an assistant public defender in Leesville, Virginia, and now she's taken over this new position. Some of you who went to public defender training here in Texas and San Antonio last year remember Colette Tevet, and who was previously in that job, and Colette's gone into private practice. And so Bonnie's come down with Diane Price, who's the public defense training manager at NACDL. And she's going to be speaking to you today. And then we're also assisted by Jennifer Saletti, who is the Director of Training for the Office of Public Defender for the state of New Jersey. And it's really great to have Jennifer because New Jersey kind of went through this process about over a year ago, but it's been 6 months ago. Okay, and you're going to hear good things about how New Jersey's implemented some of the reforms that we think are going into effect here in Harris County. So to begin with, we're going to have Diane Price come talk to you a little bit about what's going on nationally. You know, where do we fit in the scope of change in pretrial release throughout the country? And then I'm going to come talk to you about what Harris County has been doing and what we think we're going to do. So, Diane?
Hello. So I get to kind of be the cheerleader here and say what you guys are having the opportunity to do now is a really exciting thing where you can have the opportunity to really change what happens with your clients, because we all know that, you know, if your clients are out of jail, then they're able to help more with their case. You know, they can talk to their family and friends and all that and find the people that you need. So you're in a really excellent position to be able to affect the case a lot earlier. So I'm calling this the new normal because this is the sort of thing that's really starting to pick up speed across the nation, and we're going to talk a little bit about that.
As we speak, close to 750,000 people reside in America's jail system. Across the country, nearly 2/3 of all inmates who crowd our county jails at an annual cost of roughly $9 billion taxpayer dollars are defendants awaiting trial. Many of these individuals are nonviolent, non-felony offenders, charged with crimes ranging from petty theft to public drug use. And a disproportionate number of them are poor. They are forced to remain in custody because they simply cannot afford to post the bail required.
That pretty much sums up the problems with most of the current bail system. We're disproportionately having our jail beds filled with low-risk defendants. It's causing an increase in recidivism for those individuals, and it's disproportionately impacting the poor and our clients of color. The Arnold Foundation did a study about basically trying to determine what impact that additional time in jail has on low-risk defendants. And what they found was that even a short period of time, 2 or 3 days, 4 to 7 days, 8 to 14 days, causes an increase in the risk of recidivism for that population, not just during the pretrial period, but also for 2 years after that. So it's actually having an adverse impact on public safety to be keeping these folks locked up in jail. Because of that, Pretrial Justice Institute has launched its 3 Days Count campaign, which seeks to draw attention to pretrial injustice and works with states to develop common sense reform.
Our clients work at jobs where if you're absent, you're fired. Our clients live in shelters or in transitional housing, places where if you're not there for the night, your place is gone. So there are a lot of different ways in which incarceration, even for a short period of time, can really destroy someone's life.
Exactly. Jail can do for your actual life what being in a marching band can do for your social life. Even if you're just in for a little while, it can destroy you. Destroy you.
No offense meant to anybody who's in the marching band. I was, so. So these sorts of things, this increased attention to the harms of pretrial detention has gotten a lot of attention. Even the Department of Justice has weighed in a statement of interest and in an amicus brief in a couple of cases, Varden versus City of Clinton and Walker versus City of Calhoun. And in both of those, there were challenges to, a bail schedule system where these cities were setting bail just based on the offense alone. So, shoplifting, $500, driving with a suspended license, $750. And the US DOJ said, basically, you can't do that. That's unconstitutional. And not only is it unconstitutional to be setting these bails without any sort of thought to the person's ability to pay it, but it's also just bad public policy. The system shouldn't work differently for the rich and for the poor. They also, in a Dear Colleague letter in 2016, sent out to a bunch of courts this letter about how they shouldn't be employing practices that hurt the indigent, both in fine collection and sentencing and that sort of thing. And specifically, they shouldn't employ bail or bond practices that cause indigent defendants to remain incarcerated solely because they can't pay for the release. In New Jersey, the report about pretrial injustice referred to this as a dual system error. And what we mean by that is that the low-risk defendants are stuck in just because they're poor and they can't get out, whereas some high-risk defendants who may have some resources are actually able to be freed. So you've got this problem of people who shouldn't be there stuck in and people who maybe shouldn't be out getting out, so that this resource-based system isn't fair or effective. Pretrial Justice Institute also partnered with some folks and did a study I think it was in Colorado, about unsecured bonds. And what they found was that people who had unsecured bonds were just as likely to come back to court, were just as unlikely to reoffend as people with secured bonds. It also didn't have any real impact on, if someone did fail to appear, there wasn't any significant difference in the amount of time it took to get them back into court. Just because there wasn't a bail bondsman going out after them, it didn't increase the length of time that they were on the lam, or whatever you want to call it. So there's really just no good evidence right now that money bail actually increases any sort of pretrial justice.
Just look at one example, a man called Miguel. He was arrested for driving with a suspended license. The court set bail at $1,000 and he had a choice: pay it or await a trial in Rikers Island.
I had to try to borrow money from this person and this person and this person to try to get him out. He told the judge, I can't afford a $1,000 bail. So he really didn't have a choice but to plead guilty.
Now, whether he was guilty or not, the fact is a non-violent offender spent time in Rikers because he didn't have $1,000. And this is a systemic problem. Increasingly, bail has become a way to lock up the poor regardless of guilt, because Miguel was a family man who posed no danger to society whatsoever, and he was stuck in Rikers, whereas millionaire Robert Durst, who'd been accused of murder in Texas, had a completely different experience of the bail system.
I had been told by the detective that you've been charged with murder, bail has been set at $250,000.
But was your intention when you put up the $250,000 to run away?
Oh, goodbye $250,000, goodbye jail, I'm out.
Here, that's local news here. So as I mentioned earlier, this is the new normal. Looking at this, you might think, oh, pretrial improvements aren't really as widespread as this woman is making it sound. The dark blue places are the places where pretrial improvements are happening. The light blue places are places where it's not yet in place. So it's happening just about everywhere, at least in one county in each of those states. There's some sort of pretrial improvement going on. PJI sends out this quarterly publication about where improvements are happening. You guys are making the news for your litigation. You guys are making the news for your county commissioners. So one of the things that is going on with this pretrial improvement, one of the ways in which pretrial improvement is happening is this increased use of risk assessments. And I know you guys are going to be getting the PSA, and that's happening shortly, but we're not there yet. But the advantage of the risk-based approach is that it's actually scientifically or statistically, I guess, figuring out with what risk factors are more likely to be correlated with a failure to appear, with new criminal activity during the pretrial period, and specifically with new violent criminal activity. So the public safety assessment by the Laura and John Arnold Foundation includes 9 factors, and these are the only 9 factors that they're using. There's no defendant interview, they're not talking about race or anything like that. Each of these 9 factors is used in a different way, so there are actually 3 scales. A failure to appear, a new criminal activity, and a new violent criminal activity. And so not all of these are used in every scale. Here's just sort of a sneak peek of how that's used. So like age at current arrest is used for new criminal activity, but not for failure to appear or new violent criminal activity. I am not going to get into the weeds today on the pretrial safety assessment because I understand that you guys are going to get some pretty in-depth training on that from Marie Van Nostrand, who develops the tool and is much smarter than I am about this. That's happening sometime in July. Do we know the date yet, Alex?
Yeah, end of July.
End of July, great. But as good as these risk assessments are, risk assessments alone are not enough. This was a great publication that was released by the Constitution Project in March of 2015, and it talks a lot about the difference that lawyers can make at bail hearings. Defense lawyers are able to provide verified information to the judge to let them know, oh, my client has this person he can live with, my client is working at this place, my client is paying child support for these children, or has sole custody of these children. You have an opportunity to be able to actually, say to the judge, no, I double-checked on this, it's not just my client's word. Defense lawyers can zealously argue for non-financial conditions of bond. You can present information to the judge about your client's inability to pay certain bonds, highlighting their low income or their limited financial resources, and using those statutes that say that you have to set a reasonable bond to tell the judge, look, $500 might seem reasonable to you, but $500 might as well be $5 million to Joe. Sorry, am I using my hands? So a few of those studies that were included. In the mid-1960s, there was the Manhattan Bail Project. They had student interviews who presented information to judges and were able to come up with ROR bonds for people, and they determined that released defendants returned to court at the same rates as those who had to post a financial bond. In 1985, the National Institute of Justice did a study in 3 different locations, in Passaic, New Jersey, in Memphis, Tennessee, and in Palm Beach, Florida. And in that study, they randomly assigned public defenders to some of the defendants at their first appearance. And they found that first appearance representation had an interesting and important impact upon pretrial detention at each site, and that test defendants were released pretrial much sooner and also on less onerous conditions. In 2002, the Baltimore City Lawyers at Bail Project had an 18-month pilot program providing lawyers at 4,000 bail review hearings. So these were individuals who had not had counsel at their first appearance, but then did have counsel at a bail review hearing. After a bail review hearing with counsel, ROR, 2.5 times more than unrepresented people who were similarly situated, $500 bonds, 4 times more than unrepresented, or significant reduction 6 times more than people who were unrepresented. These folks who had counsel were staying in jail only a median of 2 days instead of 9 days, and projected savings is $4.5 million over that 18-month period. So here's where the advocacy comes into play. There are a lot of things that you guys can be doing to try to get your clients out or try to get your clients better conditions. A few things that I would specifically say that you should be working on is avoiding over-conditioning. That's going to be your big problem now that you're trying to go non-financial, especially on misdemeanors, is your judges are going to want to be like, well, let's make them do drug testing and make them do this and make them do that, and a lot of that is just unnecessary. And there's some pretty good research out there that over-conditioning actually is problematic for clients. You're just setting them up for failure, and it has some of the same impacts as these high financial bonds or staying in jail in general. They might be trying to pass on the costs of supervision to your client. I know New Jersey had some really good law that said that you couldn't pass on the cost of supervision to the client except for GPS, and even that, you could have that waived. I'm not sure what you guys are doing in terms of whether they can charge them pretrial supervision fees and that sort of thing. So the same thing with, talking about the conditions of release and the financial conditions. Think about those costs of supervision that they're passing on to your clients as well and try to push back against that. I know you guys are going to be doing video pretrial release hearings. You're going to be in the jail with the client while the judge and the prosecutor are somewhere else, is that right? For a while at least. So the sort of pitfall of that is, it's so removed. It's a lot easier for a judge to just be sort of uninterested or disinterested when your client is on a TV instead of actually there in person. So you have the opportunity there with your client to try to draw the judge in, to humanize your client in that position, to make it less likely that they're just, next, next, next. So basically, what I'm trying to tell you is that you have the opportunity here to be an advocate for your client and give them this. And that's the exciting part of this. If you can advocate for these individuals and get them out of jail without having to pay, they're just going to be in a much better position. They're going to be able to keep their jobs. They're going to be able to support their children. They're not going to lose the place that they live. And they're going to be able to help with their case a lot more. And I know that some of these are not going to be your cases, but I'm sure that that is just not even important. These are, you care about what happens to the client, regardless of whether that's your client or not. So let's get these folks out. That's my finish.